Ladies and gentlemen, welcome in Tuesday night. We're going to hang out here for a little while. Going to watch a little bit of this Courtney Clenney motions hearing that happened just a few days ago on March 20th, 2026. Got a link here from Court TV. We're going to check it out. I haven't seen anything about this in a while. I know there's been updates that I haven't covered, but I initially covered this pretty thoroughly. At least some of the body cam footage. I think I have done 4 or 5 videos on this. I think I even have a section for Courtney Clenney. Let's add to it tonight. Hit the like, give it a share. Let's go.
Let's rock.
Boom. What's up, everybody? Boom, 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 boom. Welcome in Tuesday night. Hanging out here on YouTube tonight. I got an hour initially here, and then of course we got members only book club following that. We're going into chapter 17 from Mindhunter tonight. Only got 2 chapters left. We're like 2 hours away from finishing that book. At least I think 2 chapters. I might be wrong on chapters, but about 2 hours at least anyways. And then we'll be picking another book. But the only way to get in there is to become a book club member, which is becoming a member here on YouTube. One thing that we're going to do while we're watching this Courtney Clenney video, I'm going to collect all the names from the last Wrestle Plunge video, and we're going to do a wheel for a free t-shirt giveaway also. And appreciate everyone for coming in. Hope everyone's having a good week so far. Let me get the chat in here so I can pop it up on screen. Here we go. Boom. Who do I see? Let me get this off the screen. Who do we see? Boom! Semi Sharp up in here. What's up? Pokemon hanging out. Well, whoa, who is this? La Llorona Ghost. I butchered the fuck out of your name, I'm sure. What's going on, Ghost? What's happening? Teresa, welcome in. Panny in the house. Teresa coming through. Holly Berry here. Shit. You probably did do it. I'd imagine if Holly Berry's here, she's done something she shouldn't have done. Just a Crazy Jen, what's up? Happy birthday, the birthday girl, and a winner from Sunday. Again, congratulations. The ghost is not invisible. Bassett Page, welcome in. I think I got everybody. If I missed you, I apologize. Oh, I see Sinead up here even. Boom. Coming through from Ireland. Melissa. What's up, everybody? Get in here. Thanks for hanging out. Well, yeah, I have not covered this in quite some time. I've been seeing, actually, Jay post a lot about this, which has been pretty interesting because I like the way Jay covers any kind of court trial, anything. He's hilarious, so it's been funny to watch. OnlyFans model Courtney Clenney. I'm having trouble with this lady's name tonight. The C's are getting. I want to look back on past streams and see if I've had, because I'm sober. All right, completely sober. Courtney Clenney is having hopefully a trial this year. I was reading today. They're thinking maybe April. We're hoping that happens. I know when I was covering it thoroughly before, dude, it was like, I feel like it was like the end of 23. I was like waiting for it, and we were here. Maybe it was 24. I don't know. I actually, that probably makes more sense. But still, I know it happened in 22, which is when I initially basically started doing something. It's been a long time. Let's get this fucking thing going. So we're going to watch a little bit here that's on Court TV. Got a link here. I'm going to catch me up a little bit as well. Yeah, thanks everyone for hanging out. And yeah, do not forget book club. And I'm going to collect those names right now as well. Let's go. Let's check this out here. Get the sound going. That would probably help. Boom.
Morning,
hopefully the audio's good.
11, it's under Courtney Clenney, but I'm here on behalf of him and Deborah Clenney, who are present on the platform. Ms. Sabrina Puglisi, who does represent Courtney Clenney on the.
Yes, Sean Abbey on behalf of the state.
Good morning, everyone.
So, Your Honor, we're here on the petitioner.
I was muted. What's up, Sharon? What the hell? YouTube doing something funky? That's awesome.
Him and Deborah Clenney's motion for a protective order, just point out housekeeping for the procedural matters. We had previously moved to intervene on the same issue. Judge Cruz had ruled against us. We took an appeal of that order. Judge Cruz's order was affirmed, PCA. The mandate was returned on Wednesday, so your honor is vested again with jurisdiction to address this current motion. We're seeking essentially what will be a similar remedy, but now under the rules of criminal procedure, which is 3.220 L&M. And specifically, and I know your honor read the motion and is pretty familiar with this. And one of the issues, or really the main issue, was that the original warrant issued for the iClouds of Courtney Clenney, Kim Clenney, and Deborah Clenney, in our argument, invaded Kim and Deborah Clenney's privacy right under Article 1, Section 23 of the Florida State Constitution. But under the rules of criminal procedure, Judge, essentially this is just all sensitive material that should not be disclosed to the state. Our issue has been not simply the breadth of the warrant, specifically, Judge, the warrant allows the state to go through Kim and Deborah Clenney's iCloud data from November of 2020 to present is what's in the warrant, but that was November of 2023. So a 3-year period wherein the issue, the subject criminal offense, Courtney Clenney's homicide charge, occurred April 3rd of 2022. So we've asked the state to narrow or at least advise what exactly they are looking for, and why they believe there would be evidence of a second-degree homicide 2 years prior or 2 years after on the iCloud data of the defendant's parents, who weren't even in the state at the time it occurred. By the state's own theory of prosecution, this was a heat of the moment incident that occurred and resulted in the death of Mr. Abumseli. So what we're asking for, Your Honor, is to restrict the disclosure to the state entirely, because I don't believe that they have sufficiently established grounds to invade Kim and Deborah Clenney's privacy to this degree. I understand and we can see that the state has an interest in prosecuting criminal offenses and has, you know, pretty wide authority to do so and many tools at their disposal, such as a search warrant, but that's not unchecked. I'll also remind the court, and I think Your Honor knows, so the warrant at issue,
I think I have everyone for the next t-shirt secret wheel ready to go, so we will do that during this episode. So yeah, thanks a lot. Missy, I see you coming through the chat. Welcome in here. Thanks everyone for coming through. Yeah, that's right.
this court has jurisdiction over, but also coincidentally, Your Honor signed the renewal warrant. Originally went in.
Hey, I remember, I feel like this is what they were arguing about the last time I did check into this case with the parents. I guess feeling like what was it? Like they've given, like they didn't mean to give access to the cloud or something like that. Is that what's
From Judge Kabarga, she executed it. It was presented to Your Honor that had gone stale and you needed to re-sign it. So I think Your Honor also has wide discretion to act sua sponte on limiting that warrant now, because you still have jurisdiction over it. Either way, what we're seeking is to prevent the state from invading our client's privacy. The court does have a secondary remedy available to it, which is to review the materials in camera and determine what, if anything, may be relevant and is worthy.
Oh, shit.
Being disclosed to the
I can
state.
fix that.
And the last point, Judge, is when the state sought this search warrant, the reason being that they could not access the defendant Courtney Clenney's iCloud or phone. They had requested the password. That was declined by Ms. Clenney's counsel. That issue has now since been remedied. So there's really no reason whatsoever for the state to have access to the defendant's parents' very private data.
Mr. Aguilar?
Yes, Judge, and before I begin, may I just request from the defense the items specifically that they believe would be protected under some privacy interest?
Well, Judge, we're talking about iCloud data, so I think that's been well established in Riley v. California that the data that we keep on our phones and our personal computers and now in a cloud storage, we're talking about medical records, financial records, spousal communications. It's a digital vault
Is this her in the orange here sitting behind this attorney?
that they are traipsing through.
And the accounts that are at issue, I'm assuming, are the KDC ones and the DEF.
Correct.
Right, the CTC is Ms. Clem.
Yes,
Right.
and just in response again to Mr. Abuhoff, it's not this private citizen with a privacy interest job to tell you this is what I don't want you looking at. It's the state's burden to say, I need to look at this because it is relevant to this prosecution.
Mr. Aguilar?
So Judge, the issue here, and I will agree with the defense that they have standing under these specific
Yeah, that kind of rings a bell also, actually.
statutes
I'm
solely
gonna
for
find
the
some
purpose
more
to limit
information.
that disclosure. A lot of the case law that comes about happens once it's already in the state's possession, and the third-party public record request comes about for these items in that disclosure. I don't want to necessarily go that far, but where we are here is, this is a search warrant that this court signed, that issued and agreed that there was probable cause for this, for the obtaining to attempt to locate items relevant to this investigation. So at this time, that standing that the defense may have to limit possible disclosure does not call into question, cannot call into question, because they don't have standing to challenge the warrant itself. If they were granted the ability to intervene, we're in a different ballgame. That's not where we are. So they're talking now about what already exists and limiting its disclosure. Now that it's already there and it's already what would be in the state's possession, we're in a world where they're limiting, their sole ability is to limit its disclosure to the public. So first off, when it comes,
I do not agree with that, Judge. I don't read the rule. I think it is far more broad than that. And it's important to note, Your Honor, that the decedent, Mr. Uphamselli, his counsel filed a similar motion for materials related to Mr. Uphamselli. So
I think that's also irrelevant to this argument.
One thing that is interesting from all of this, because yeah, for motion for protective order filed by Courtney Clenney's parents, they sought to restrict the states, and it ends with why I remember this, because this is not the first time this has went in front of a judge. They sought to restrict the state's access to data from shared iCloud accounts seized via search warrant. The parents think that this is an invasion of privacy under the Florida Constitution, claiming overbroad fishing expedition, and the iCloud data was relevant to the investigation, but prior motions to intervene slash squash the warrant slash return property were denied. So looks like they haven't gotten lucky with this so far.
Per se, because whether or not it was granted the defense and the state were in agreement to limit some of the more sexually explicit conversations or things that the court
30 months,
deemed
holy
were,
shit.
obtained illegally. That's what the purpose of that protective order was.
It's amazing. This is my happy place. So glad to be here with you all. Thank you so much for always hanging out. Shelly, you're awesome. One of the, God, I mean, 30 months, that is a long ass time. Time is flying by. My God. But you've been so kind, so awesome, so amazing. I really appreciate you always coming through. I see Mosh coming through the chat as well. Oh, he was showing off his 37. Oh, shit. I see what Spark did now. Dear Lord, man. Yeah, these OGs. Insane numbers. I don't even know if I can say, is that 1,620,600 minutes of publicly buzzed nation? 1.6 million minutes of publicly buzzed for you, my friends. Kai, thanks for coming through here. Thanks, everyone. Appreciate y'all. Seriously now.
Welcome to the party, pal.
Yippee-ki-yay, motherfucker.
But that being said, Judge, if you look at the rule itself, outside of the first sentence, all of it talks about depositions and limiting what would come about. For this is section L. When it comes to the disclosure, the state can be limited in asking these questions for, or a witness to have to answer these questions. None of it pertains to items that are already in the possession of the state itself. These items itself, the court took possession of it after the fact and held on to it for the purpose of the appeal and whether or not they could intervene. And I believe the court's intention then was, okay, if they could intervene, we could talk about the breadth of this warrant, they would have standing to. Now they don't. You know, that the third DCA, the court said they did not, the third DCA approved and affirmed that they did not. And so what we're here now is talking about items that are already effectively in the state's possession, although the court has it. And now the question would be limiting it and basically its use in trial.
33.
Or third parties. So where we are
That
here,
is crazy.
and when it comes to this item, these items, when the defense talks about
Time flies when you're having
financial
fun.
record, that's very relevant to this case in
We've
and
had
of
a
itself.
wild
You know,
time
when it
with
comes to
publicly buzzed,
Ken
y'all.
Clenney's financial records, it was clear in the Arthur hearing that Ms. Clenney, the defendant, sent all of her money to the defendant in
20.
the months
Damn.
leading after, even 1 or 2 months leading.
Coming up on 2 years
or
now.
preceding the murder itself. So we do have
Love all
an
the way from
interest in obtaining
Ireland,
finding the
baby.
value within that and seeing how it fits into our
Yeah, you
case
guys are the
for actions taken after the fact, as well as
Crazy.
communications with Deborah Clenney that happened in the moment of this murder and homicide. So
That I get, but what we're talking about 18 months prior to the homicide itself.
So, and Judge, the issue comes is that all of these, I understand Your Honor is separating each account, and rightfully so. But when it comes down to it, all of them share one iCloud account. So when we do a return for this iCloud, all of this comes, and you can now attribute to each person their separate phone numbers. So they share, that's the first part of it. The second part is that what Your Honor has just done is what the defense would like is to attack the warrant for being overbroad, for calling into question the amount of time in which we are being able to look at certain information. And they don't have standing to do that. And that's the problem here, is that they can't question what Your Honor found probable cause for in our investigation in trying to obtain certain information. That's why, they do have standing to question what could be turned over, or in a deposition of Deborah or Ken Clenney, what could be asked. But when it comes to what's already in the state's possession that Your Honor found probable cause, they can't question that and they can't challenge that.
So
They being the Clenneys, so in other
Well, not
words,
Clenney's, Kim and Deborah.
right, that's what I mean, not.
Yes.
Courtney.
I can address that as well, Your Honor.
Okay, let me just make sure, were you finished, Mr. Agarhoff, or? So in your argument, if the motion to intervene had been granted, then we would rightly be in this discussion that we're having, but because it wasn't, and it was affirmed on appeal, it's as simple as a threshold standing issue,
Correct. And I actually, that's not correct.
okay?
Because standing would say whether or not they could even bring this motion altogether. The rules allow for them because they do have a privacy interest in the records themselves, but the question has or the answer is the state has a competing interest in still reviewing and obtaining and ascertaining value to some of these items.
If I were to say that the privacy interests of Mr. Kim and Deborah Clenney outweighs the state's interest in prosecuting this case, what type of limitation would be appropriate?
What I would say, Judge, would be that Your Honor, prior to any sort of public record request for these items, and this is obviously a very media-driven case where there's a lot of attention to it. Anytime that a public record request is done or requested for specifically these iCloud returns, that it could come before the court and we could be able to ascertain in camera or even, just off record of, hey, these are the items that you are not allowed to turn over to the public because that's where their public or their privacy interest now trumps the investigation or, I'm not finding the value. State, explain to me now why the public needs to, or you should have been able to ascertain or obtain these items.
So your position in that regard is this is not right.
To be fair, Your Honor, I've never seen the returns. I've never seen what's on these returns, and my involvement in this case when the returns came back, it was not as a first chair prosecutor. So I would love to say, Judge, this is everything that's on. But I'm not allowed to have communication with who was previously the first chair.
Right.
So I would say yes, but legally speaking, it could be right. Because in theory, there are people in our office that would have that information, just not any that we could discuss with.
What I mean by right is that the actual public record request has not occurred yet in this.
Yeah, Brooklyn, I've been waiting on this one for a long time. I started covering it when I thought it was going to be around the bend, and then it got pushed out. And then I didn't forget about it, but I just been waiting for something else. I know that they've done some motion hearings that I haven't covered, but see that I think it's going to be happening next. Wait, I just read today. Is it happen? It's happening very soon though. So I'm getting back into it here, trying to get ready. So yes. Well, mostly on X. I'll be mostly covering it on X and on Tuesday nights. I'm not going to be doing nothing insane.
Regard.
In that regard, then yes.
Maybe it has. Obviously I don't know the answer to that.
If there are any public records requests for the iCloud warrant, we have not been able to answer to them because they've been in possession of them.
Okay.
So let me just address the issue of the public records request, because I think that's a red herring.
It might be because
Yeah.
it's separate and apart from discovery.
I agree, Judge. And I also need to point out that we're discussing a privacy interest. So for my clients, the state going through their private data is the same invasion as if it was
all over the
requested.
news.
It's
Yeah.
somebody who should not be looking at what is private and being allowed to do so. I also want to address, Mr. Abuel talked about under subsection L of the rule we cited to and said notwithstanding the first sentence, but the first sentence is particularly important because it is what gives us this standing on a showing it could cause the court shall at any time order specified disclosures be restricted, which is what we're asking for.
Starts on 4/20. There you go.
Happened today. Judge, it's also important to note on the issue of the motion to intervene. And this is particularly problematic because I don't think even the state is arguing that my clients don't have an interest in their own data. The third gave us no opinion, so I'm not gonna, speculate as to what they think, but they did deny the motion to intervene, which puts us in a very interesting position because the state has sought very private data over a long period of time of two people who just happen to be related to the criminal defendant. And now is essentially arguing that we don't have any remedy before Your Honor. And that is a really, really steep and slippery slope for us to be on, because that subjects everybody who may know someone prosecuted by this state attorney's office to have their very private data reviewed. It's also, Judge, essentially a moot point because they have Courtney Clenney's data on the other side. So anything related to her, who is the defendant they are prosecuting, that may involve my clients, they have it through that back door. So there's no reason for them to be looking to private citizens' very private data on the other side of it. So, and again, I've yet to hear in all of the arguments, what are we looking for? With regard to the financial issue,
That
that's
sounded to me like if it went more toward the motions that you, well, not you, but that Ms. Pavisi and Mr. Praetor raised with respect to her release.
Say that again, Your Honor.
Well, the financial records and whether or not
Right.
Ms. Clenney has been provided with money for her to flee the jurisdiction.
It's a very
Discuss
interesting.
that before.
Yes, Judge, because Mr. Clenney did testify at the Arthur hearing. Mr. Abuov's predecessor, who was removed from the case,
Didn't mean to cut the judge's face off.
put in one of his response pleadings that the warrant was sought for this information for exactly that reason, because they believed this was a movement of money, which was indicative of flight. The warrant was sought after the pretrial detention order was entered. So that's just a disingenuous argument to make. the idea that transfer of money for somebody who's now been in custody going on 4 years was not just a sound financial decision. It does not establish anything related to the elements of a second-degree homicide. And there's no issue of flight because she is detained. So that argument, I don't think has much merit, Your Honor.
Can I ask, if I agree in part with your argument, what limitation would you suggest? I realize for the record that you're objecting to everything and that this, in its entirety, but I think that some of this could be.
Sure. We offer in the initial motion to allow for a limited release of the phone calls or communications between Deborah Clenney and Courtney within the time period of the homicide. I can even concede that that would be relevant and important to the state's investigation, but to have 3 years of private data for a very limited window of time, I don't see the state offering the court anything compelling. As far as our standing to challenge the warrant, I'll concede that point that Mr. Abuhoff made, but that does not prevent the court, having reviewed the warrant, from acting sua sponte with your jurisdiction over it, to limit it and say, okay, well, what are you looking for, state? Give me more specifics.
What is the earliest date of, because my notes are in my office, the earliest date of some of the interactions that we litigated, I don't know, a month ago or whatever, prior to the homicide?
So, and Judge, that's the problem. We turned over for the Arthur hearing. There's the specific incident between Ms. Clenney and her parents when she's about, I'm guessing right now it's either 12 or 14. It's sometime in that range. So that's many years before. And this idea of—
Yeah, I don't care about that. I'm talking about.
I understand
the
it.
defendant and the alleged victim.
And I understand that. So their relationship is about 3 years, or about just under 3 years prior to the murder. It's on and off. There's multiple conversations, but that's the problem here is I believe that date coincides with when that relationship began. And it's seeking, and a lot of the conversations and knowledge of the Clenneys, they were quite aware of what was taking place between their daughter and Mr. Obumseli, to the point where the week before the homicide, Deborah Clenney is coming to the apartment to now address any sort of issues as to what is going on between them. So there's knowledge between the parents and their daughter and their daughter's relationship. And I believe that is why the date was what it was. I wish I could give Your Honor more information as to that, but that is, at least it coincides with when we believe his relationship with her began.
So, Your Honor, I'll allow Ms. Puglisi to make the relevancy objection to all of that when it's appropriate.
Yeah,
I mean, that's a bridge too far.
I know. I just was trying to get a sense of,
And Judge,
because I signed this 3 years ago or something.
Yes, ma'am.
So I obviously can't recall what was in my mind or.
Been a long ass time.
So-
and I'm sorry.
It does
Jesus
seem overbroad.
Christ.
I
Welcome in,
apologize,
Carrie.
Your Honor, for interrupting. But the question of whether
Look at
it's
her face.
relevant
I know.
doesn't necessarily
She's
mean
like,
that
you
it's overbroad.
motherfucker.
The idea is their relationship starts at a certain date. It is certainly relevant. The question of whether or not it's relevant to the trial and whether Your Honor will allow us to go into it as to some Williams rule component, that's separate and apart from PC relevant in this case. And I believe that's why, although Your Honor now is looking back and saying it might be overbroad, it's relevant to their relationship. And so it's not a fishing expedition for things. It's seeking information of knowledge between very pertinent and important witnesses, especially Deborah Clenney, who is on the phone at the time of the homicide and even potentially after the homicide, or at least we know for sure after the homicide, and Kim Clenney, who's on the phone, or not on the phone, but in discussions with their daughter, moving her out after the homicide and financial actions after the homicides, but also their communications beforehand with their daughter.
Harkening back to what I said a few moments ago, in that I do believe that to some extent, Mr. and Mrs. Clenney's privacy interests outweigh the state's interest in prosecuting the case. If I were to grant the protective order from November of 2021 to 2023. No, April of 2021 to November of 2023. How would that harm the state's ability to prosecute this case? And that would call into question the fact that I do believe to some extent that their privacy interests outweigh the prosecution.
So in this, the problem here, Judge, is that when defense comes here and asks for the entirety of these iClouds, the problem is that there are specific items that would be relevant. So Deborah and Kim could be Williams rule witnesses. I won't know until I get to review these iCloud warrants, which have been in the court's possession for the last couple of years. Right now, we have a pending Williams rule motion,
Right.
but we can only litigate it so much so until we figure out their knowledge and their witnesses to what exactly, I don't know. So the date range that Your Honor is suggesting, I believe that you're cutting the state out by its legs when it doesn't necessarily have to. At the end of the day, the protection, the privacy interests that they are seeking, I think is covered by limiting who is able to see it after. So if the public cannot receive it, and the question is still, it may be relevant to prosecution and what the state may be able to use.
But how are we 4 years in and you don't know the answer to that question?
Because Your Honor has had the iCloud warrants or the returns for the last 2.5, 3 years. The only person who reviewed those prior to is no longer on this case, and I can't speak to him. So
Judge, the point Mr. Abeloff just made is very telling. They may be Williams rule witnesses, but we don't know, so we want to go fishing through their data to maybe explore a 404 motion. That's putting the cart before the horse. The state needs to have some reasonable belief that these witnesses have relevant information, so much so that they're going to be allowed to be called separate and apart from the facts of the trial.
I bet Bob Mata's loving this one. Yeah, I mean, it sounds like they're making some good points about why they maybe shouldn't get it. That's interesting.
Put up as Williams rule witnesses, but the answer keeps coming back. What are you looking for? I don't
But it's
know.
been
because
so
I haven't
long.
looked yet.
that's not my answer.
Well, you don't know because well, partially, but you can't speak to the other prosecutor as well.
So, and this is the problem, Judge. So, we specifically were looking for communications, financial data. They can't be separated out. When iCloud receives these warrants, they're not picking and choosing. They're not the ones who go and say, hey, here's exactly what you requested. They are taking the entirety of it. They're sending it to us. At that point, we end up sending it over to the defense, and the proper way of handling this is having a taint team be able to review it and, hey, defense, we're not looking at it, it's in possession of the taint team. Tell us what you believe is something that should be excised out of it. Which can still be done here because anyone who does have knowledge of this is not on this case anymore. So what can be done, what should be done is, this is given to the taint team that the court has approved. They are
Which
able.
now can happen since the appeal has come back.
Correct. And so now that these items are here, they can be taken by the taint team. The defense who received copies of this at the time that they came in as part of discovery should be able already to know what's on this rather than the state, because anybody who had knowledge does not. If there's anything that they want excised off, then they should be able to bring that to the taint team that they can take it off. If there's a question truly of, does the state have a competing interest in this, then we bring it to the court and say, Judge, we're not in agreement. But this is something that should be taken off, like outside the presence of the court. We can handle this together in theory until we can't. Like, that's why it's not. The defense should be able to lay out exactly, even broadly, to the taint team, hey, all of these items should be taken off. We should be able to say, hey, we're in agreement completely, and then it's not an issue. If there's an issue, now we bring it to the court, and Your Honor can now look at it and make sure.
Supervisor Domo, are we premature?
No, not at all, Judge, because the state's conflating an issue here.
I never said she didn't have nice tits. I never said that. You can still be a murderous bitch. Weirdly, being still narcissistic and weird. That's what got me, is like the way she's acting in some of these clips I've seen. What I got that picture from, with her like sticking her tongue out. Who the fuck is she looking and talking at? Like, has that ever been disclosed? Is there a new boyfriend? I should be worried. Because if anybody remembers, we did streams with videos showing and depicting exactly how insane Courtney Clenney is. Absolute fucking maniac. I remember that. Maybe I do need a full-on refresher and go back through some of that shit.
Same team is applicable to Ms. Puglisi and Mr. Prieto as the defense. I'm not the defense here, Judge. I am protecting my client's privacy interests, which frankly applies when members of the government, the state attorney's office, is reviewing their private data. It's a constitutional amendment in Florida's constitution that creates a robust privacy interest. That argument pertains to whether privileged communications will be reviewed and is more applicable to Courtney Clenney and her defense team. Our position is, you're the government. You don't get to look through private citizens' data just on a hunch because you think there may be something in there. And that's why we argued the warrant was overly broad. They didn't identify anything that they're really looking for and still cannot tell this court. And this is probably the fourth or fifth hearing we've had. Nobody's been able to say exactly what they're looking for. So we're just gonna open up a digital vault and let them peruse it at their leisure and look through very private.
Like, this is an interesting argument, especially for someone like Bob that, you know, could really get into the argument of this and like lay it out. But also, as a person that's just watching this from the sidelines, that does not have to choose either side, quite frankly, and just wants the fucking tea, just wants the juice. Yeah, I want all of it, baby.
Material while trying to find something that may be relevant that they don't even know if it exists.
What is your position as to a possible limitation that I suggested previously?
So I think that's actually a fair compromise, Your Honor, but I would suggest this. I think the date would be limited from April of 2021 to when Ms. Clenney, Courtney Clenney, went into custody. Because their argument was that they want these communications, any communication she had with her parents while in jail.
Oh shit, it's fajitas right now. When I talk, it's fajitas right now.
They have ready access to through jail calls. So I think if we limit it to around the time of the homicide to when she's taken into custody, the state's interest is preserved. It respects the very robust privacy interest of my clients, and hopefully this case can proceed to trial as scheduled. April 2022, thank you.
Judge, specifically to that April 2022 date, now that cuts out any.
How about now? How about now? Is it more clear now? Hopefully that worked.
Anything beforehand. So you're eliminating any sort of Wilkins rule information that these parents may have.
All right, the motion for protective order as to April 1st of 2021 to August 26th of 2022 is granted.
Thank you, Your Honor. I'll draw a motion. Oh, wait. It's April 2022, Your Honor, is when the
What's up,
homicide.
life artist?
That's not what my order is. It's 2021. I'm allowing it the year before.
And Judge, forgive me, but let me inquire of the court, if you don't mind, what's the rationale for the year prior?
The continued, well, you know what, now that you say it, it's the communications that I think would be appropriate, but that's part of Ms. Clenney's.
And they have access of that through Ms. Clenney's material. Also, Judge, the argument that she may have discussed her relationship with Mr. Obamselli with her parents, and therefore the state should be allowed to see that, again, creates a very slippery slope, because you're allowing private data of parents who are having communications with their child about their relationship to be looked at because they may indicate their feelings one way or the other. There's this homicide is being prosecuted as a heat of the moment second-degree murder. So any discussions that Courtney Clenney had with her parents about her relationship is trying to shoehorn in something that's not going to ultimately be relevant or admissible.
Which is again not your purview necessarily.
Fair enough, Judge, but while I'm trying to protect my client's privacy interests, I'm addressing the state's argument to say, hey, they might have talked about the relationship, so we should be allowed to look at that.
I'll give you one last comment on that.
So Judge, specifically to that point, defense says that there's a privacy interest between conversations with themselves and their daughter. That's just not true. That's not protected by Florida state law, not protected by federal law. And specifically now you're bringing in a party to this dispute, marital spouse, if we want to talk about those communications, that is the only protection that could pertain here. But once Courtney's a part of it, that is waived when it's brought to another person. So the discussion that they want, the question here is relevance, and that's what they want to argue. And that's really the only thing they can argue. It can be completely relevant, which is why when that relationship is going on, which is why the beginning of the warrant was the date that it was. So yes, that's what every search warrant is. If we knew that every conversation was in there, then yeah, that's great. But realistically, you're saying, hey, we have probable cause, a crime was committed. This is the parent. These are communications that were had.
Oh my God, I was muted, son of a bitch. Oh, fuck. Oh my God. I went in. I did it. I did a lot. Oh my God. Welcome the hell in here. MBW007. You're in the book club tonight. Oh man, I was pumped up. I was pumped up on it. Shit. Get in here.
Party, pal.
Give me the loot. Give me the loot.
Man. I was a little bit muted. I was spitting.
After the fact, we want to ascertain their communications before the fact. So this is very normal in the sense of all search warrants ascertain a specific amount of data for specific
Son of a
purposes. These
bitch.
communications now
It looked like a good one.
being limited by the court, I think may go too far. We respect the court's ruling and we'll abide by those, but at the same time, it is relevant.
So I'm gonna stand by the 2021 date, so if you could draw up the order.
I will, Your Honor.
And, the bottom line is, as to Courtney Clenney's iCloud, it's all still fair game with the dates that are in the search warrant itself.
I understand that, Judge, and that's.
Yeah, and Judge, are you allowing the state to look through everything or just communications? And just very briefly, Your Honor, I was not making a privilege argument. I was making
we're not there.
Right. I was making a privacy argument.
Right.
But again, I guess my question to the court for purposes of this order, the state's arguing that they need these communications.
It's limited to communication.
Okay. All right.
Judge, I would argue that financial records matter as well. I mean, there's an argument here, Judge, that specifically Mr. Okumseli was, for lack of a better term, leeching off Ms. Clenney throughout their relationship. She's getting money from her
This is
parents.
going to turn into a telenovela.
I
Okay,
understand
so
that. But
that's the issue.
So
Let me
that's
just say this. If during the course of your investigation, now that you're able
Judge is
to
a little
go through
spicy.
everything, that we're back to where you're able to do that, that you need to revisit something that's part of the court's ruling, then you'll do it. But as we sit here today, it's communications.
So, Judge, and that's why what I'm talking about now is during that Arthur hearing, throughout that entire transcript, the defense argued that Mr. Okumseli was leeching off, which is why he's back at that apartment. We need to be able to ascertain because she's not making the money that she's making at the time of the homicide for the year before. So that's why financial records are going to say, hey, Kim is sending money to their daughter for those during those purposes. So financial records are relevant for this purpose. And that's why, defense is asking for everything that other than conversation, but other things that are inside of this iCloud are pertinent to this, including medical records. They may be in receipt of medical records. Courtney Clenney, who actually claims that she's been a battered spouse. So this is important. And to limit us to be able to obtain these items that could be there is a problem. So, Your Honor, we'd ask for the date range with everything. Defense has it. They should be able to tell the court, hey, Your Honor, this is here. They shouldn't be able to look at that.
I mean, I think Mr. Contradomo's argument was that, private citizens should not tell the government what they can and cannot look through when you're not a party to a case.
Right, and that's why we come here, Your Honor, and it talks about specific disclosure of those items. So they have it, and that's why they have possession of it. They should be able to tell the court, you shouldn't be able to look through this because this in fact exists, and we have an interest in this. Then we'd be able to actually have an intelligent argument with the court to say, Judge, this is why this is relevant to us. To now blanketly just say, medical records. That's not what this statute is meant for. And that's the problem that we're here now, is that they're blatantly asking the court to cut out everything for that date range. So, Your Honor, the date range itself, we'd ask for everything in there. We're happy to provide a copy to Mr. Facciadomo. If he's arguing that we don't have an interest or their privacy interest trumps something, again, that's why the team is here. So this is something that I think, again, it's putting the cart before the horse. It's something that can be handled throughout this process. And now to sort of blanketly say, state you can't look at anything but messages, now cuts out potential evidence that is more than relevant and may come into this trial.
I think these dudes just need to fight. I think they need to just start scrapping.
Is what it is. That suggests that the court ruled that the date range that I know you're not in agreement with the date range, but it is what it is. That all of the property that is contained in pages 2 and 3 of the affidavit in support of the search warrant be allowed, notwithstanding whether it has to do with communications.
Right.
Mr. Facciadomo, any last word? I actually think I'm revisiting that at this point.
Well, Judge, if you're revisiting it, then yes, absolutely. I think the state's argument is essentially shifting the burden onto private citizens to prove that they have a privacy interest in the data that they want to look through. That's just not how the constitutional amendment works. It was very much designed to create in private citizens a robust privacy interest. To say that we think there may be something of relevance in here, and I frankly admit, I said this with all due respect, Mr. Avaloff, I think the financial argument's a bit tenuous at best. It was originally raised as, like Your Honor pointed out, as an issue of whether Ms. Clenney was a risk of flight. So going through private financial records for which my client's interests are protected doesn't have any relevance to a second-degree homicide trial, and trying to shift the burden onto us to tell the state what we think is private in our private material is not the right calculus for this court. They should be able to tell Your Honor, this is why we think this, and point to, with some specificity. I get that they need to review evidence and items that they received from a search warrant before they can decide if it's going to be relevant to the trial. But there needs to be at least a certain amount of specificity. Your Honor saw this warrant. It simply listed everything that's included in iCloud data. So I think asking us to then tell them what they shouldn't be looking at is shifting the burden onto us and making private citizens responsible for telling the government, here's what you can't see.
And I think I would agree with you 100% if the taint team was not in place in this case. I think that is the safeguard at this moment in time. So
May I respond to that?
yeah, go ahead.
So again, I have to bring this point up because, and Your Honor, the Article 1, Section 23 states every national person has the right to be let alone and free from governmental intrusion into the person's private life. The taint team are members of the state attorney's office. They are the government intruding into my client's private life, who are not charged with a crime. They were, but that was folly and dismissed. So partly because they invaded privilege. So there's all sorts of problems here. They have a right to be free from governmental intrusion. The issue of the taint team is more for the trial against Ms. Clenney. Kim and Deborah have a right to not have random members of the state government look at their private data. That's what the amendment is for.
I'm going to rule that from 4/1/21 to 8/26/22, the protective order is granted. It will solely be as to communications at this point for that period of time. In the course of your investigation, if you wish for the court to revisit that, then you may do so. But at this point, it is limited to communications.
Judge, may I ask for clarification on the communications? Is it between my clients and their daughter or any communication with anyone?
Yes.
Doctors, lawyers?
Yes.
Okay.
Judge, so just so that I'm clear, so as it pertains
Everyone.
to your warrant, that you signed
So
initially,
she granted.
is your honor ruling that it was overbroad?
As it pertained to Kim and Deborah Clenney.
And then when it comes to the items that are sought, is it your honor's purview that the standard for obtaining a warrant is what the defense has said that it is here? Whereas, in reality, the question just comes whether there's probable cause to believe that relevant evidence could be discovered during these searches. Because they're
Right, but
seeking.
now we're 4 years later, we recognize where we are procedurally, and as it comes to the two private citizens that are at issue, it's a very different calculus than it was back in November of 2023.
But it's not though, Judge. The only difference is what we're effectively here for is now a motion to suppress because the items have already been obtained. So the question would be whether or not those items, and that's why, they can limit the discovery of it in some respect, but we have our own interest in our own property. So those iClouds that the court has maintained possession of is the state's property in and of itself when we obtain those items. So that at that point, we're no longer in this world of 3.220 as it pertains to a protective order for the state, because it already has it. Where we are now, and that's where the argument is that it goes to the public disclosure of it. The question of whether or not we can now look at it goes to a motion to suppress. And now that's why this is the standing issue in and of itself of whether they can raise this under this statute. So with that in mind, we have to ask the court at least to lay out its argument here that this is not the avenue where it is, just with whether it's on record or in a written order, because this slippery slope now allows for any defendant to say that someone that's not arrested can now say, you can't look at my records other than communications with this person.
But that's when there's a reasonable suspicion to believe that a crime has been committed. That doesn't apply to Mr. and Mrs. Clenney.
But it does as it pertains to evidence of a crime. And that's the issue, is when we're talking and discussing the nature of a relationship, a lot of things become pertinent. And that's the problem here. That's why I have no issue with the court limiting the dates. And perhaps that's something we could have done before, but limiting the dates to what Your Honor did, but then to limit the evidence within those dates, that's, Your Honor is effectively saying we don't have probable cause to believe that any of that could lead to evidence of a crime. And I just think that's a slippery slope.
I can't think of a reason right now why that would, because you're prosecuting this as a heat of passion crime.
No, Judge. We're calling this a second-degree murder, where specifically she is reacting as nature, as part of their relationship over time, over the 18 months of this that boils over. So what the state would argue, she now stabs him in the chest. Defense now wants to call it a heat of passion crime, but this is a buildup throughout it. And there's
So Mr. and Mrs. Clenney's medical records would have something to do with that?
And I'm not saying that specifically wouldn't, but your order, Your Honor, cuts out everything else, including the medical records. But that's why I can't even tell you if it's on there, and that's the problem. The problem is right now, if Your Honor wanted to look at the iCloud dumps itself and lay out specific items, fine. The only person who has knowledge of what's on those iClouds is the defense. And they haven't put anything in front of the court to say, by the way, there are medical records on them. They said the likelihood of
I
it,
can
but they
put that on the record. I'll put that on the record.
Okay.
Yeah, it's an iCloud account.
Everything's there.
Everything's on it.
That doesn't, no, that's not how this works.
Okay, I tell you,
But this is.
I've got a packed courtroom full of people who are waiting. It's now 9:52.
Wow.
If we need to litigate us more, we can at the end, but
So the
I
defense
thought I
won.
had ruled.
Yeah,
And I think
agree.
new issues are now coming up. All of
Yeah,
them.
and Judge, what I'll do is I'll draw up an order in accordance with your Honor's ruling. I would suggest if the state finds something in those communications that allows them or leads them to believe that there's additional
Yo, Tiff.
information out there, that's how an investigation should
And that would
progress.
be
And then
brought back.
we can readdress it with the court.
But Judge, so I would ask that we brought this case at the end
We
of
can
calendar.
continue to argue.
Yes, I would ask that this be brought up at the end of calendar. There's still more.
I am restricted in my time, Judge, and I understand the court has rules.
Yeah, I think I
Just
had.
as Your Honor was
Yeah, get the
rethinking
fuck
your
outta
ruling,
here,
and
I
then
think
they
she
had a
said,
final conversation,
basically,
I have
right?
now asked Your Honor, and Your Honor, now there's more topics to be discussed. This is a slippery slope, and this is a big problem,
It's
Judge.
looking like the state's
Because
gonna
at the
fuck
end of
this
the
up,
day,
and she's
Your
gonna
Honor
walk to
granted
me.
probable cause for an entire range. Your Honor's read through that warrant, found that there could be evidence to suggest of a crime to support that crime, and now Your Honor's rethinking, saying it was overbroad. Fine, but the idea to limit what the defense says could be on there, the idea is that that's not our burden to show. The idea is to say that there could be evidence of a crime. If they want to come before the court and say, Judge, this specific item is here, we'd ask that that now not be allowed. That's different than what is happening.
I don't agree with that.
Okay.
So here's what we're gonna do. He's gonna draft an order. He's gonna show it to you. If it comports with what I've said right now, fine, I'll sign it and execute it, and you can move for a rehearing.
Thank
All
you.
right, we're back
Thank you.
4/16, but I wouldn't mind having a date before that.
That the sound you
Oh
make?
my
Yeah.
god, this is gonna
When
get
we
pushed
do
out
it,
again,
please
isn't
don't
it?
do it.
Jesus Christ. All right. Hopefully this thing gets rocking and rolling. I think it's going to be an interesting one. Yeah, I mean, maybe a future murder church full trial. I could see that happening. But I'll be covering it on X for sure. If you're not following Publicly Buzzed on X, please do so. I can't even figure it out. That follow Publicly Buzzed on X. I will be covering it on there, I believe. I'm going to maybe try to do some update streams on here even. And there is a Courtney Clenney playlist right here on this channel that you could check out as well. Go to playlist and it should be in there. And the last time I covered this, it's been a while, but it's kicking off again. We're getting ready to go into book club. If you're not in the book club, get in the book club. That's the only way to join us for the next hour. And we're going over not even going over, we're listening to chapter 17 of Mindhunter. And we're almost finished with this book, and we're going to be going into a brand new book very soon. I mean, within probably two to 3 weeks, I would imagine. So, and I'm going to need the voices of the members to help me figure out the next book that we dive into. Otherwise, I'll see you Friday night, Frill Friday. We'll be watching something fun. Come hang out. And again, a new look is coming to Publicly Buzzed. I'm working on it now. Trying to figure out a new vibe to the stream. Later, guys. Or come on over to book club. Do it.
Disperse! Nothing to see here, please!
Wait a minute. I forgot to spin the wheel. Hold on. We got a wheel to spin. My bad. Got a wheel to spin. This is the secret wheel. Right here that we're doing. So J Money, Simi Sharp, Jennifer J, Teresa, Ashy Snow, Daria, Pammy, Ember Burns, Bassett Page. Thank all you guys.
Give me the loot!
But thank you all for coming through.
Sober enough to know what I'm
On the
doing,
secret
and I'm
wheel.
drunk enough to really enjoy doing it.
Who's gonna get the shirt? Teresa wins the shirt from the secret wheel. Keep an eye out for when I say secret wheel. And the way to get on that is to leave comments and likes on my new wrestling videos over on Wrestle Plunge. And this one was won by Teresa. So hell yeah, that's how we're going to close out this bad boy. And I'm going to put it in my notes before I even shut her down. Teresa, I think I spelled that right. Hopefully I did. Is she in here? Hopefully she didn't dip. Teresa shirt. Boom. I sent out J Monies today. Let's go to book club.
This hurts.